Cracking the Code, 3rd edition, Part 1 Theory. Here we go. Section 2, The Truth About Esquires, Undressing the U.S. Judicial System. The truth about Esquires, undressing the U.S. judicial system. Probably the most fundamental, foundational datum that must be confronted by today's student of the law is such student has any hope of achieving ongoing success in the application of knowledge of law is that all law, and this statement includes every genre of codified law in existence capped off by the Uniform Commercial Code, has been stealthily and artfully converted into private corporate policy, and that the administrators of this corporate policy are none other than actors within and without the insolvent, bankrupt commercial enterprise known as the United States, and its creditors, the Federal Reserve and International Monetary Fund Syndicate. Governments use laws. Corporations use policies. This is one reason why the term public policy has replaced its predecessor, public law, in common legal parlance, the news media, and everywhere else. You may have wondered why the term United States in the previous paragraph is not preceded by the word the. The United States is a solecism institutionalized by constant use over a long period of time. There is nothing plural about the contemporary use of the term United States. United States is a singular proper noun, and the correct usage does not include the antecedent definite article the. United States is a corporate trade name, like General Motors, and identifies a corporation, albeit federal and municipal, but a corporation nonetheless. Just as General Motors does not imply a plural number of motors that are somehow general in nature, United States does not imply a plural number of states that are somehow united. Just as proper English does not include the Canada, the Finland, the Egypt, and the like in common parlance, it likewise does not include the United States. And the implication of the plural number of states slyly and injuriously implants an erroneous notion in the mind of readers and listeners. Just as the state of Great Britain appears in the Declaration of Independence in 1776, and the state of Israel is mentioned daily in the news media, the state of United States is far more accurate as an identifier for what is erroneously conveyed by use of the solecism, the United States. United States, the proper recital of the name, identifies the for-profit, bankrupt commercial enterprise incorporated in February 21st, 1871 in Washington, D.C., presently managed by the receiver in bankruptcy, Secretary of the Treasury of Puerto Rico, aka Secretary of the Treasury. All right, let's read some of these things real quick. Solecism, an ungrammatical combination of words in a sentence. Okay, let's go number 2. From 1776 to 1789, the United States were a confederation. After 1789, it was a federal nation. Excerpted from the definition of federal in a standard dictionary of the English language. Okay. Number 3, the U.S. government incorporated as a for-profit commercial enterprise in the Legislative Act of February 21st, 1871, 41st Congress, Session 3, Chapter 62, page 419, and chartered a federal company entitled United States, that is to say, United States 1871, also known as the U.S. Inc., a commercial agency, originally designed as Washington, D.C., in accordance with the so-called 14th Amendment, which the record indicates was never ratified. See Utah Supreme Court cases, Diet versus Turner and State versus Phillips, as well as Coleman versus Miller and Tulane Law Review, also South Carolina Law Quarterly. And check all those out. The United States government is a foreign corporation with respect to a state. Okay, number 5. Location of the United States. The United States is located in the District of Columbia. So that's the Uniform Commercial Code, Section 9307H. Secretary of the Treasury of Puerto Rico was appointed receiver over bankrupt United States in Reorganization Plan number 26 in 1950. Title 5 USC, Section 903, Public Law 94-564. Legislative History, page 5967. Secretary, the Secretary of the Treasury of Puerto Rico, Title 27, Code of Federal Regulations. Okay. The title Secretary of the Treasury is a euphemistic abbreviation of the actual title, Secretary of the Treasury of Puerto Rico, also known as Secretary. See the glossary. Here we go, next section. A most insidious jurisdiction. The following legal precept, however simple, reveals the source of more personal and international grief, misery, suffering, despair, chaos, and loss of life than can presently be imagined by nearly anyone outside the inner circle, and that is, payment or consideration sets the form of law. That is to say, the mode of payment in any particular transaction sets the applicable jurisdiction for resolution of any dispute or controversy arising out of any matter concerning the transaction. This unassuming little aphorism points the way for the serious student of history, politics, and economics, past all the highfalutin authorities and through the looking glass, and into the sprawling spectacle of the most pervasive and all-consuming confidence game in the history of the world. It transcends all national boundaries and establishes venue for the unqualified commercial conquest of mankind, the artificial, private, corporate jurisdiction of Federal Reserve notes. All courtrooms in America today are commercial marketplaces dealing in matters bearing exclusively upon the private commercial script known as Federal Reserve notes. The notion of the halls of justice is an ancient fable. Today's courtrooms are impersonal businesses under the jurisdiction of a foreign, occupying military power that are managed from the bench, or from the bank, Italian banca, by the merchant bankers called judges and magistrates who enforce private, copyrighted, corporate policy known as code, wholly owned by British corporations. The business of the court consists of admitting attorneys wishing to conduct business and adjusting and balancing accounts between debtors and creditors transacting in Federal Reserve notes, or FRNs, who come before it and consent to have disputes resolved in this, America's modern judicial form. Next section, Esquires. His definition. Esquire, from the Middle French esquire. Esquire, shield bearer. From Lower Latin, escutarius, from the Latin scrutum, shield, plus arius, airy. Is defined as originally a shield bearer or armor bearer, an attendant of a knight. In modern times, a title of dignity, next in degree below knight and above gentleman. Okay, so Webster's Revised Unabridged College Dictionary. All right, there's a couple more definitions. In English law, a title of dignity Next above gentleman and below knight, Black's Law Dictionary, 1st edition, 1891. Next definition, a man belonging to the higher order of English gentry, ranking immediately below a knight, applied to various officers in the service of a king, as a title accompanying a man's name. In the U.S., the title belongs officially to lawyers. So that's the Oxford English Dictionary, 1971. Dignity and nobility are synonymous, interchangeable terms, and the word manipulators use each to deflect attention from the other whenever needed. Nobility means the person collectively who enjoy rank above commoners and peerage as the English nobility, the qualities which constitute distinction of rank in civil society. According to the customs or laws of the land, this or that eminence or dignity which a man derives from birth or title confirmed and which places him in an order above common men. Webster's Dictionary, 1828. Dignity means, in English law, an honor, a title, station, or distinction of honor. So that's in Black's first edition. The state of being noble, an elevated title or position, a person holding an elevated title, a right to hold a title of nobility, which may be hereditary or for life. That's from Black's 7th. Elevation, honorable place of rank or elevation, the rank or title of a nobleman. Webster's, 1828. So as you can see above, an esquire is a title of nobility holding shield bearer for the king or queen of England and takes the lead against any with whom the crown desires to engage in battle. Officially, all bench officers, bar member judges and magistrates, and attorneys in America are esquires, officers in service of the crown. In legal and commercial terms, they are foreign-based merchants in commerce. See UCC 2-104. These guys are enforcing the private corporate policy of their British liege, lord, and employers against unruly colonial belligerents, and that's the American customers, who are deceived and coerced into using the commercial script or currency of the private, foreign-owned Federal Reserve Bank, and who also, out of ignorance, bewilderment, and the instinctive urge for survival, continually attempt avoidance and sometimes even unlawful evasion of the corporate policy. For example, the Internal Revenue Code, governing the privilege and benefit, albeit compelled, of using such. Today, all crimes, including murder, are classified, characterized, and addressed strictly as commercial pecuniary changes by the militaristic merchants who own and operate the legal system, issue the codes, and dictate over government. This fact is officially acknowledged in Title 27 of the Code of Federal Regulations, Section 72.11. This single section of Title 27 alone confirms the undeniable supremacy and applicability of the UCC in all legal matters in every American courtroom, as well as others throughout the world. Okay, next section. Debunking the mythical license to practice. Newspapers and television media chant incessantly about the so-called license to practice law. Bar association attorneys do not possess any such license to practice law, but they are nevertheless accused of it in California business and profession codes. in which one can only be held as lexical legerdemain. Brilliance of the devious use of words. Of the highest order, the code encrypting esquires in government have successfully bamboozled even their own kind in convincing all of the existence of the almighty license to practice law. The following analysis should thoroughly disabuse anyone of any misconceptions. Whereas the notions of a license to practice law is scarcely mentioned in the state and federal codes, the requirements and parameters surrounding every other kind of license in existence are spelled out in mind-numbing detail. For example, the vehicle code, the internal revenue code, etc. The sacred license to practice law, however, is as undefined and elusive as the wind. Where it comes from, which agency of government issues it, whose signature is on the certification, how it is confirmed, where one goes so he can see one of these things and examine it, what the tenor or duration and effect period of the license is, what the cost of the license is. These and other intensely pertinent questions remain unanswered by the codes that voice the implication of its existence upon us. Here is a front row seat of observing the word manipulating esquires, both in and out of the government, in action. California Business and Profession Codes, Cal B and P, the 6000 series, of which is also known as the State Bar Act, at Section 6002, is the solitary code section in all of California code that proclaims that any such license was ever issued, but it does not also tell us which government agency issued it, and likewise where one can go to see one of these things. The same code discusses the practice of law and bar membership. 6125, necessity of active membership in state bar. No person shall practice law in California unless the person is an active member of the state bar. 6002. Members of the state bar are persons admitted and licensed to practice law in this state. These two sites appear innocent enough, but a glaring outpoint is that they reference entirely different jurisdictions. 6125 is applicable only in California. 6125 pertains only in this state. California means the original de jure California Republic as described in 1849 California Constitution. In this state, however, per California revenue and tax codes, means the de facto federal territory under control of District of Columbia, also known as the United States, and expressly excludes the de jure California or the California Republic, whereas California as a sovereign constituency, that is to say, flesh and blood men and women living on the land under the common law in the state, signifies the federal state of California, which its subject, citizens of the United States, persons existing under statute in an artificial realm. There is no other plausible, coherent explanation for using the identical term in each section. For this reason, and this reason alone, Section 6125 and 6002 bear no meaningful relation with each other. Both sections cite only persons. The only persons in California are corporations and other corporately colored entities or trade names. Since the de jure California essentially disappeared from the legal scene with the arrival of the U.S. bankruptcy in 1933, 6125's proclamation makes as much sense as the vehicle code asserting no person shall drive an 18-wheeler on Route 66 unless that person is a member of the Teamsters Union. Okay, next section. What is the State Bar of California? A potentially fatal discrepancy in both sections cited above is that the entity named, that is to say the State Bar, aka the State Bar of California, does not legally exist. The California State Constitution, Article 6, Section 9, and the California State Bar Act, codified in Cal B&P 6001, respectively, make the following proclamation. Section 9 of the Constitution says, the State Bar of California is a public corporation. 6001, the State Bar of California is a public corporation. All bona fide corporations, public and otherwise, must be registered with the Secretary of State. The corporate seal promoted on the letterhead of the State Bar of California indeed bears an incorporation date of July 29, 1927, but the Secretary of State's office informs this author that per their records, State Bar of California as a public corporation does not exist. See State Bar, not a registered public corporation, in appendix for a printout of State Bar's missing listings as a public corporation in the California Secretary of State's online records of corporation. Speaking with 12 different personnel at the headquarters of the State Bar in San Francisco, as high up as the Executive Director's Office, no one can answer the following questions. What type or legal classification of organization is the State Bar of California? Next question. What is the significance of the alleged date of incorporation, July 29, 1927, on the corporate seal touted by the State Bar on their stationery? Why does the State Bar of California advertise a corporate seal if the alleged corporation attached thereto is non-existent or defunct and unregistered? Why is there no record of the State Bar of California as a public corporation at the Secretary of State's office when both the State Bar Act and the California State Constitution by amendment in November 8, 1966, at Article 6, Section 9 specify that the State Bar of California is a public corporation? As of this writing, February 2002, the Office of the Executive Director of the State Bar of California is circulating a memo within State Bar offices that describes the nature of the organization for all employees. As quoted over the phone by a very helpful senior administrative assistant at the offices of the State Bar, who shall remain unnamed, said this. The State Bar of California is a constitutional agency in the judicial branch of state government, and the purpose of the State Bar is to act as the administrative arm of the California Supreme Court in matters relating to the regulation of the legal profession. The only problem with the above advisory memo is that the constitutional agency is not how the Constitution and the State Bar act. Legislative acts that created the State Bar identify State Bar of California. Both specify that it is a public corporation, not a constitutional agency. Complicating matters, California's Secretary of State refuses to issue a certificate of non-filing, a $5 fee, a standard form for any unregistered, non-filing public corporation for the State Bar of California, claiming that the State Bar Public Corporation was formed by statute or legislative act, and therefore not formed in accordance with the California Corporation Codes. Hence, lack of the statutory authority for the Secretary of State to issue the certificate. State Bar of California is broadly and openly touted as the public corporation, but has cleverly exempted itself from registration to conceal its books and records. Resolving the paradox and revealing the utter deceit and criminal intent of the state bar and the disassemblers that created it is the following obscure cite from 7 Corpus Juris Secundum 9. Says, in view of decision that creation of public corporations by special acts is prohibited by state constitution, state bar acting, creating state bar corporation as public corporation has no viability, and designation of state bar as public corporation has no legal efficacy. So that's bridegroom versus state bar, and you can see it in there. State Bar Act creating the State Bar was a public corporation, has no viability, and the public corporation formed thereby has no legal efficacy, but the State Bar enjoys the best of both worlds anyways, as a parent agency of the government, enjoying the power and protection of the state, including exemption from taxation, but in actuality a private institution without legal basis, a conglomerate of sycophantic flunkies or attorneys at the beck and call of judicial system that enforces copyrighted law of British corporations, operating outside the bounds of law that the rest of us must contend with every day just to survive. How could we expect anything less than the profession whose very existence is predicated on the ongoing ignorance of this victim customers, that is to say, its practices and policies? Section 6002 tells us members of the State Bar are admitted and licensed to practice law. Admitted into what? Licensed by whom? The word mastery of this simple proclamation, in both satisfying the reader's perfunctory inquisitiveness, yet firmly establishing ambiguity, boggles the mind. Reading these two California Business and Practices sections, one might get the idea that the State Bar members are the only ones who can ever obtain a license to practice law. However, because of the way Section 6002 was worded, non-members of the State Bar are not excluded from being admitted and licensed to practice law in the state. Similarly, as shown below, bar membership is a result of, for example, follows being admitted and licensed to practice law in the state, whereupon the admitted party is then granted membership in the State Bar and a bar card, not the other way around. Generally, membership in a bar association is optional with the individual attorney, but where a unified or integrated state bar organization is established, membership and payment of dues may be required as conditions of practicing law in the state. Corpus Juris Secundum 8. Perfunctory, done merely for the sake of getting through, mechanical and without interest. Okay. California B&P, Sections 6125 and 6002, are the only two code sections that bring bar associate attorneys into the realm of legitimacy. A recap of significant discrepancies. Only State Bar members can practice law in de jure California, which was, for all practical purposes, disposed of on March 6, 1933. For example, Section 6125 is pure camouflage. Though the media and courts would have us believe otherwise, non-State Bar members are not excluded from being licensed to practice law in this state. State Bar members have been licensed to practice law, but when and where and how and by whom we are not told, and California Business and Professions Code requires membership in a non-existent defunct public corporation. The State Bar of California does not issue licenses, cannot issue licenses, because it is nothing more than a freewheeling private trade union posing as agency of government, quoting from a statement issued by Governor Pete Wilson office in May 30th of 1998 article from the LA Times entitled "Wilson Suggests Change to Let Bar Survive." Quote, "The bar now acts as a trade organization promoting the legal profession, while continuing to regulate and discipline attorneys, a dual responsibility that many of its own member attorneys call a conflict of interest," said a statement issued by Wilson's office. If the state bar were indeed the source of the mysterious license to practice, then it would be an absolutely indispensable component of the California state government, an impossibility, without which no attorney could be licensed. Proving the impotence of the State Bar of California and the falsity of the licensing myth associated with it is the following article from April 14, 1998, edition in the LA Times. Quote, "The beleaguered State Bar faces uncertain fate. Agencies. It will begin going out of business as a result of Wilson veto unless the legislature acts quickly." Quote, "Critics 2 years ago launched a referendum on whether to abolish the bar, but with just over half the state's lawyers voting, the bar survived. About 65% of the respondents opposed dismantling it." Quote, "The bar has escaped other brushes with death. In 1985, the legislature refused for several months to allow the Bar Association to collect dues because of its abysmal record in disciplining lawyers. If the existence of the Bar Association hinges on the internal vote of disgruntled critics, that is to say, Bar Association attorneys complaining about paying dues and disciplining themselves, and could have easily been abolished in 1985 and 1996, the State Bar of California can be dismissed as irrelevant as the source of any so-called license to practice law. However, the apparent intent is to bring about the idea in the mind of the public that the attorney's bar card is his license to practice law. Sneaky. Regarding the conduct and professional standards of Esquires, there is no state or federal regulatory agency in America governing such matters, quoting Oceanside, California Republican Assemblyman Bill Morrow, who sponsored a bill for overhauling and shrinking the bar in 1998 in the same LA Times article immediately above. Quote, "Morrow said that he is not worried that the lawyer discipline will lapse. If no legislative breakthrough is reached by summer, the legislature will simply transfer lawyer discipline to the State Department of Consumer Affairs," the lawmaker said. Bar associations function merely as labor unions, like the Teamsters, just as membership in the Teamsters Union does not confer the privilege of driving. Membership in the Bar Association, likewise, does not confer the privilege of practicing law. Rather, the membership in the Bar Association is a result of being admitted and licensed to practice law. The notion that a Bar Association has any obligation to discipline its members is fantasy, and whatever occurs is gratuitous. State Bar Associations cannot be very different than their parent, the American Bar Association, a voluntary membership association of attorneys per their website. Each one is substantially nothing more than a union of local mercenaries, military personnel for hire, carrying a foreign title of nobility and operating under the aegis of the judicial system, which has a vested pecuniary interest in the proliferation of its members. Next section, Attorneys at Law. California Business and Practices 6067 specifies that it is merely a person, not a member of the state bar, that must have a certificate of his oath of office endorsed upon his license. quote, every person in his admission shall take an oath to support the Constitution of the United States and the Constitution of the State of California, and faithfully to discharge the duties of an attorney at law to the best of his knowledge and ability. A certificate of oath shall be endorsed upon his license. We are not told what is meant by admission in this code section. This will be revealed below. But if the bar card were the same called license to practice, then the above referenced oath would be inscribed upon it, certificate form, and endorsed. No bar card, a credit card size piece of plastic, has any such endorsed certificate of oath of office upon it. The only text appearing on the bar card of the State Bar of California concerns annual union dues. This certifies that the person whose name appears on this card has paid the annual fee required by statute. Punctuating this whole matter, your authors are personally acquainted with more than one practicing attorney at law who is not a member of the bar. If such attorneys at law are admitted and licensed to practice law in this state, and do so, yet are not members of the Bar Association, upon exactly which license is their oath to support the Constitution of the United States endorsed? The actual so-called license to practice, next section. The reason British Esquires can practice law without a state-issued license in American courtrooms is that the courtrooms are no longer de jure government instrumentalities or operations, but rather private, monopolized commercial venues or marketplaces for enforcing the private copyright corporate policy, that is to say, the statutory and legal code of the owners of the code and of the Federal Reserve notes. As mentioned earlier, possession of a bar membership card, as in any labor union, means only that a particular Esquire has attained at least some degree of expertise and that his or her union dues are current, and nothing else. The answer for the above uncertainties apparently lies in California Business and Professions Code, Section 6064. Admission on examiner's certification. Admission certificate. Upon certification by the examining committee that the applicant has filled the requirements for admission to practice law, the Supreme Court may admit such application as an attorney at law in all the courts of this state and may direct an order to be entered upon its records in that effect. A certificate of admission thereupon shall be given to the applicant by the clerk of the court. First of all, the fact that a separate body, the examining committee, must certify that an applicant has fulfilled the requirements for admission to practice law is further evidence that simple bar membership does not confer a license to practice law. Otherwise, the Section 6002 would be sufficient in itself, with no further requirement for being licensed. Regarding the true importance of the so-called examining committee referenced above in the Section 6064, the Chief Justice of the Supreme Court can unilaterally overrule its decision and admit an applicant that has been rejected as unfit or unqualified. The admission to practice law is controlled ultimately by the Chief Justice of the Supreme Court of the jurisdiction. Quote, Supreme Court has inherent power and authority to admit an applicant to practice law in the state, despite unfavorable report upon its applicant by the Board of Governors of State Bar. So here's your reference. The authority of the Committee of Bar Examiners is limited to investigating and recommending for admission those applicants found by it to be of the prescribed standards. Only the Supreme Court has the plenary power to admit applicants who, in the opinion of the court, meet the prescribed test, whether or not the committee agrees with the conclusion of the court. Other sections of the code reveal that the license to practice law follows admission to practice law, not membership of the Bar Association. 6060.5. Neither the board nor any committee authorized by it shall require that applicants for admission to practice law in California pass different final bar examinations depending upon the manner of school in which they acquire their legal education. 6060. To be certified to the Supreme Court for admission and a license to practice law, a person who has not been admitted to practice law in a sister state shall 6064 subsection 1. No person who advocates the overthrow of the government of the United States or of this state by force, violence, or other unconstitutional means shall be certified to the Supreme Court for admission and license to practice law. Okay, let's see. This plenary means full in all respects of requisites, entire, complete, also complete as embracing all the parts or members. A real-life example of the true nature of the so-called license to practice law, taken from a November 10th, 2001 article in the LA Times entitled "Clinton Resigns from the High Court Bar." Former President Clinton hereby respectfully requests to resign from the bar of this court. His lawyer, David E. Kendall. Clinton's resignation from the Supreme Court bar will have little practical impact. Clinton has not practiced before the Supreme Court and was not expected to argue any cases in the future. Clinton resigned only from the Supreme Court bar and from no other bar. The former so-called license to practice in question is the certificate of admission issued by the British Esquire Chief Justice of the Supreme Court, just like the one issued in de facto state of California, where the Chief Justice has final say-so over who gets licensed. Every other license to practice law held by Clinton for doing the certificate of admission does not fit the definition of license per se, but is a de facto license, as proven below, issued by the Supreme Court of the jurisdiction. All right, next section. Source of the license and the British title of nobility. Since the code painstakingly avoids ever actually naming or identifying the imaginary license to practice law, we must look deeper to discover the true nature of the certificate of admission and why it is construed as a license to practice law. An underlying aspect of the certificate of admission, and likely the only reason we are ever even told of a license to practice law, is because it is the equivalent of the right to practice law, revealed in 7 Corpus Juris Secundum 4, page 801, and the actual reference case. In this state, the right to practice law is conferred by letters, patents, issued under the Great Seal of the state by its chief executive. The right to practice law is a property right existing by virtue of letters patent from the state as a sovereign. All right. The word patent is defined as below. 1. A. Manifest or apparent to everybody, requiring no search to discover, conspicuous, evident, plain, as the fraud was patent. Patent? Maybe it's patent. Covered or definition number 2, covered or protected by letters patent. secured from interference by government protection. 3. Open for general inspection as letters patent. Noun. 3. Law. A grant of any privilege, franchise, etc. made by sovereign authorities. So that's Funk and Wagnall's Company, Standard Dictionary of English Language, 1903. Okay, here's a different one. Number 1, a government protection is an inventor. So this is a patent. A government protection to an inventor, securing to him for a specific time the exclusive right of manufacturing, exploiting, using, and selling an invention, the right granted. Hence, any official document securing right. Okay? So let's read that again. The right to practice law is a property right existing by virtue of letters patent from the state as a sovereign. The true relationship between the Crown and the United States should be coming into focus. The source of a patent, as well as letters patent described below from the beginning, has always been the sovereign, the Crown, the originator of this device, because the Crown had a supreme need for disguising its commercial interests in America, while continuing to conduct business in the name of its strawmen, Esquires. The notion of a sovereign artificial United States or a so-called sovereign state, had to be concocted and introduced into the legal world, officially proclaiming the United States a sovereign, thereby endowed the enterprise with a sense of legitimacy and propriety. While still controlling utterly, however, the destiny of the new corporation via its Esquires. For Esquires, the chain of command still runs to the Crown. The actual case cited in Corpus Juris Secundum above, 168a, 229, 14th New Jersey Esquire, 868, sheds more light on the phenomenon. In this state, the right to practice law is conferred by letters patent, issued under the Great Seal of the state by its chief executive, in branch supra. This has been the custom from the very beginning of the province of New Jersey, in Han supra. So, that attorneys at law in New Jersey are the holders of a franchise granted by the state through the governor by letters patent by the same authority as formerly was exercised by the British Crown. 1. Pollock and Maitland's History of English Law, 191. A franchise is a royal privilege or a branch of the king's prerogative subsisting in the hands of a subject. A special privilege conferred by government on individuals and which does not belong to the citizens of the country generally by common right. Since the right to practice an ordinary calling, business, or profession is property, it follows that the right to practice a profession conferred by the state as a franchise by virtue of what was originally the king's prerogative is a property right. Interesting, property rights. Investigating letters patent, we find history. Okay, here's the first part. A document granting some right or privilege issued under government seal but open to public inspection. Black's 7th. Here's another one from Black's 1st. An instrument proceeding from the government and conveying a right, authority, or grant to an individual. And here's one from the Standard Dictionary of English Language, Funk and Wagnall's Company, 1903. From within the definition of letters patent, an open document under seal of the government granting some special right, authority, privilege, or property, or conferring some title. No attorney can produce a valid state-issued license to practice law, and no such license exists. However, there is such a thing as a right to practice law, which is in special property right, and as confirmed above within corpus juris secundum, said right is granted by means of letters patent. The so-called license to practice law can be none other than the letters patent. Certificate of admission, a document that can only be construed as a fabled license to practice law, and then only covertly by and within the judicial system. As confirmed in the dictionary definition of letters patent, immediately above, the British Esquire-run Supreme Court, in the granting of letters patent, tacitly confirms the British title of nobility, Esquire. Attorneys at law are free to begin using their new title upon receipt of the certificate of admission. Bar membership is incidental, not non-essential. The right to practice law follows in the wake of the letters patent and establishes a sham strawman between the judicial system and the people. Since there is no requirement that the attorney at law identifies himself as an esquire, there must be some other factor at play that induces such extraneous behavior. Admission to the practice of law is membership in an ancient and honorable profession that has for its goals the furtherance of the administration of justice, and the attorney is an instrument for the achievement of such noble purposes. McFarland versus George. Professions includes much more than the mere management of the prosecution and the defense of litigated cases. Commonwealth of Pennsylvania versus Wheeler. Accepting employment entails duty to courts and faithful performance of services. 7. Corpus Juris Secundum, page 801. One who is admitted to practice as attorney at law, both by virtue of his oath of office and customs and traditions of the legal profession, owes to the court the highest duty of fidelity. What better way of advertising one's true colors, the source of one's newfound power, other than voluntarily affixing the addendum, King's Esquire, at the end of one's name? British corporations have now copyrighted and own every type of code within the entire U.S. judicial system, as cited in footnote 13 on the second page of this treatise. The private policy of British corporations is being enforced in American courtrooms in the form of a property right bestowed upon a special class of citizens who become British esquires. Black's Law Dictionary is copyrighted British law. Ooh, interesting. I did not know that. Whereas the Bar Association is presented as the supreme force in the legal realm, it is actually only a club of private henchmen under the control of the Supreme Court, which grants a special property right to practice law in letters patent disguised as certificates of admission, thereby covertly conferring the title of Esquire upon recipients. The corrupt, unregistered, and illegitimate Bar Association dutifully slinks along behind the master. Nevertheless, a vital tool is the design of the legal masters of the world, a storefront for deflecting public scrutiny and providing a semblance of piety within the legal profession. Esquires carry out the business of the crown, let's say extraction of both participatory payments arising out of the original commercial joint venture between the colonies and the crown, and the war reparations called war contributions. Okay, see war contributions in the glossary. All right, and we will start part 2 next time with the fox guards the house hand section.